we're speaking about the offer to purchase level, simplifying it, we're talking about a legal document that has the conditions in order for that purchase to go through.
Yeah, so what we're basically saying is that everything that is stipulated according to that contract is what's going to go on. The first point that I'd actually like to speak about is submitting one offer at a time. Now, I know as property investors, you'd say that, no, submit multiple offers at a time, and you'll see that
not only property investors, I mean, people will be like, I love both these properties at the same time. I can love two properties at one go.
So the first one that will agree to my terms is the one that I'm actually going with, of which is incorrect. The reason why I'm saying it is incorrect is if you have signed on the offer to purchase, you have binded yourself according to those rules and regulations of how that contract is actually going to go. Now, if it happens that both people or both properties accept you at the same time, it means that one of them is not going to be able to sell the property with you. Now, how does that actually affect you? You can actually face a lawsuit based on that you have signed a contract and you said that you are agreeing to the terms and conditions and selling the property. Now, you might have to pay off the estate agent because they were using their marketing material, and you might actually have to pay the owner. So that's something that you have to be aware of. Now, what we like to do as property investors, I mean, some estate agent has actually went on the other route. Some estate agents have actually found this up, where property investors say that I would like to put in an offer of X amount of money, right? And I'm saying it verbally. If I'm saying verbally, you can't take me to court for something that I said verbally. Hence, you'll find a lot of estate agents saying that I do not take any offer unless it's written on paper. If it's written on paper, then you're legally binded to it. However, if you're setting multiple offers verbally, that's how you can actually curb it.
And Levelman, I know a lot of people would love to be defensive, saying that, no, but why should I then be paying the seller? Because let's be honest, let's look at it this way. If you put in two offers,
and you're only going to buy
one, right? Now, what's going to happen is that let's think about the seller. Let's put ourselves in the seller's shoes. So now that seller, that means there might have been a situation whereby they turned other people who were to buy them away. So ultimately, that means their holding costs are going to be more because of the decision that you took. So of course, now it makes sense that that person should come for you. It does make sense.
It does, 100%.
So the second point, right, is that I would like to touch base on the 72-hour clause. We're being technical today. So let's go back to the content, right? Looking at the 72-hour clause. So what can happen is that the seller can actually put it in the contract whereby they're having the 72-hour clause. So what this means is that, yes, even if you put in an offer to purchase in black and white, as Lebo did mention, but what would then happen is that if someone does actually come with a better offer to the owner, he can then accept that.
Okay.
During the duration or until the deal has been sealed. No, until the deal has been sealed.
Okay.
So what that means is that if I'm getting, let's say you are the buyer. Let's say.
So what we basically say is that the owner can still cancel if he gets a better offer. However, he has to tell you within 72 hours.
That's it.
Okay.
So if Levo was the buyer in this case, and then he put in an offer, just some offer that I didn't understand, right? And I wasn't comfortable with it. But I knew that my property could sell higher. Man, I don't know why we're speaking about this because, man, this can come back to hit us. So what then happens is that, but here's the case, right, is that I need to come back with that offer and show you that it has been signed. Because now it can't happen whereby I'm just telling you as the person who has submitted an offer that there's another offer put in. I need to show you in black and white that there has been another offer put in.
Now, the thing that I'm actually seeing with offer to purchase, right, or contract that you're actually going to be signing when you're buying a property is that it is flexible and everything that you want can actually be placed in the offer to purchase. So, like, for example, the 72-hour clause. A standard offer to purchase doesn't have the 72-hour clause.
It doesn't.
Hence, you need a conveyancer to actually draft that for you and put it in contract. Because if that's not on the if that's not on the contract, and you are saying that, no, I saw the video from the guys and the guys said that I can use the 72-hour clause, only to find out that that wasn't in the contract. Now you are trapped between a rock and a hard place, that now you've got the second offer to purchase and you've also signed it as a seller, right? Now the buyer can also come after you and say that, why did you actually agree to this if you knew that this property is actually being sold? So at the end of the day, what we're saying is that everything that you are agreeing upon needs to be signed on that paper. Now that you spoke about the 72-hour clause, right, from the buyer's perspective, now let's look at it from the seller's perspective. So in the seller's perspective, there's a cooling off period, right? So cooling off period basically says that for properties, this is what I'd like to highlight. For properties that are under 250,000, there is a cooling off period, right? So the cooling off period normally will be between 10 to 5 days, right? Between 10 and 5 days, depending on the agreement that you have with the seller. Now, the cooling off period basically says that if I try to buy your property and you are like, okay, I'm selling my property, right? I can then say that, let's say on the fourth day, say that I made a mistake, can I please withdraw my contract? Now, in that case, that puts me in a situation whereby I can still go back on the deal. Now, here's the problem. People hear the cooling off period and assume that it is there for every property. Number one, it needs to be on the contract. Number two, if the cooling off period has actually ended, it then becomes a bit harder for you to go out of the contract. Now, we have actually gotten people out of contracts because some things were just not looking right. So I'll give you an example of what had happened. The problem was that on the offer to purchase, the people or the owners had said that they are the owners of the property, whereas the owner was someone that had actually passed on. So the property needed to first be transferred from the person that passed on to this person that's saying that they are the owner.
Our client was so happy when she got out.
They were so happy.
And that's why you need no help on your side, guys. Make sure that you just reach out to us, man. You can't invest in property without us. It's a no-go.
They were so happy. They were so happy because now the question was that it had been some time while this property was actually being registered, and now this person is seeing that there's actually something wrong that's going on this property. Now, only to find out that the people that were selling the property were now trying to consolidate or wind up the estate of the person that had actually passed on. Now, the question is that you were untruthful. You were not truthful on this particular contract, whereby we are saying that by the time I signed this contract, the property wasn't registered into your name. Now, because of that, I want to actually go out of the deal. And then they went out of the deal. And also remember, there's something that's called suspensive conditions, right? Now, when you're speaking about suspensive conditions, we're talking about if these things are not done, then I'm able to go out of the contract. Or if these things are not done, I can come back to you and say that you haven't actually fixed this. Can you please come back and fix this?
So from my side, bro, is that it's 1-0 because of the 72-hour clause. It was more on the buyer side. So the sellers mustn't feel jealous. I've got you guys, right? So let's also protect the sellers. A lot of people when it comes to buying properties or selling properties, they think that the offer to purchase only protects the seller. So it's more of a document, a legal document that I got from the seller, and my duty is just to give that $1 million signature. Whereas it's not the case. You did mention that the buyer can provide suspensive conditions. So what we're then saying is that the buyer saw the property, the buyer read the contract, the buyer called Non-Wealth and the team and said that, gents, please help me out to make sure that am I protected within this. And then we noticed a couple of things whereby you needed certain items to be fixed or you needed certain items to be altered. So that's where you now have the power in terms of, I would love these conditions to be included before the sale goes through. Now, what is very important is terminology now when we're dealing with the law side, when we're dealing with these type of contracts. Because now if you don't put a date to it, it's a problem. Because sometimes you could say that I would love you to fix the roof. Now that doesn't say that doesn't say when.
I like that.
So the seller could say that, yes, I am going to fix it, but maybe after the transfer. Or the seller can still say that I am going to fix it, but they're having financial challenges. Now you find out that it's about to be transferred. Now the question is that you want out, only to find out that you wanted to use that condition that, no, you didn't fix. And then the seller's like, there was no date, there was no time frame. And I'd like to also stress the importance again of being aware that when it comes to time frames, we should understand there's a huge difference between working days
30 days
and 30
also
days
30 calendar days.
30 calendar days. Like that plays a significant role because you find out that it's about to be transferred on the 29th day, only to find out that you didn't include the weekends. So that ultimately works at your disadvantage. And that seller would be like, no, I'm still within means because you counted weekends.
At the end of the day, it goes back to reading, not only reading the contract, but also getting the attorney to go through the contract.
That's it.
Because there are a lot of jargon. There's a lot of jargon that happens within the contract that sometimes the normal person won't actually understand what's written there. Right? So now the difference between it's the small things that are put into the contract that actually lose a lot of people. Things like what Neo talked about right now, looking at calendar days and 30 days. Those are different things, and 30 working days. Now you're also looking at the seller may, or the seller can, or the seller has to, or the seller should. Those little things are actually really important. Now if I'm saying that the seller should fix the property before the property is actually registered, and the seller may fix. Now if you're saying may, you're actually giving me an option that I may not, I can or I cannot. So at the end of the day, what we are saying is that if you are going to go into a contract, not only yourself should be reading this, but you actually have to take it to attorney for them to actually go through that whole contract and then come up and tell you that, okay, based on the contract that I read, this is what I think.